Good morning, everyone. I'm Chris Parker. This is Kristen Ishihara. We're at the law firm of Ishihara and Parker here in Longview, Texas. And today we're answering one of those questions that we hear often. You meet with someone, a family comes in, they usually have had a death, and they say, hey, what is probate? And Kristen, what is probate?
Yeah, well, I think I've gotten better over the years about trying to, when someone comes in and we prepare their will, just talking to them a little bit about what probate is, because I have recently had multiple people come in and say, oh, well, I thought my will was set up so I didn't have to probate it. Yeah. That is impossible. So if your estate plan includes a will, which it should, then that will to transfer title to anything has to be probated, and so few people really understand that those are like the same coin, different faces. So if you have a will, it has to be probated to be effective. When someone dies, you are not automatically their executor to handle their affairs. So just I think this should be a short video, but we did want to talk about if I have a will and that is my plan for transferring title, I should expect that my will have to be probated, and I need to let my executor know just exactly what probate means.
Right. So your loved one comes in, they write a will, they do their powers of attorney, and you think you're done. That is not the case.
Right.
The original will signed by your loved one in front of the witnesses and notary, which hopefully you're dealing with, that needs to be go to an attorney. It needs to be sent to the court itself to go through what's called the probate process, where the original will is actually presented to the judge. It does not happen automatically. If you are in a blended family, if either one of you has children from before marriage or your spouse has children from before marriage, and that will left you things, you need to see an attorney to discuss that will. That will is only good for a certain period of time.
Yeah, so what probate means is that you, as the executor named in the will, hopefully have retained an attorney in the county where the person who died lived at the time that they died. You and that attorney file an application to probate the will in that county court or probate court. You and that attorney appear for a hearing before the judge, and the judge says, yes, this is a valid will created under the state laws of Texas. Yes, you've been appointed as the executor, hopefully as an independent executor with the power of sale. Here, I've signed an order admitting the will to probate. I've appointed you as the executor. Now, you have what are called Letters Testamentary, and you get a tax ID number, and then anything that's made payable to the estate or in the name of the decedent, now you can open a bank account and put it in there. That's the other, I think, phrase that people aren't familiar with. So I went to the bank, and I tried to get Mom's bank account, and they said, I need Letters Testamentary. Can you write me a letter? Nope. Yeah. Letters Testamentary means you have probated the will and you have been appointed as the executor, and that is a court process that you have to hire a lawyer for.
Yep, and starting at the beginning, the application's fairly simple. You need a decedent's social security number, the applicant's social security number, the decedent's address, your address, obviously the will, to be able to read the witness's names.
But the original will.
The original will.
The original wet signature will, all of the pages.
Yep. You take that with the application, you take the will, you file it down in the courthouse within 4 years of the decedent's death. That way it's effective. You take it to the courthouse, notice is filed, you eventually go to court. Very easy process here in Gray County, Harrison County, Upshur County, surrounding counties. We have good judges. It's not a complicated process for 99% of the clients. The judges understand how these cases are done. They're very good at them. You go to court. You ask about 20 fairly straightforward questions. The court looks at the evidence, looks at the will, looks at you, and says, okay, I'm comfortable moving forward. And at that point, you receive those letters of testamentary, which I always tell everybody are like the key to every lock, right? If you got a check given from somebody that's made out to the estate, well, that's the key to unlock it, right? If you have land that needs to be transferred or changed, that's the key. So you get the key from the court, from the clerk's office after the court approves everything.
Right. It's just a legal process, but you do have to go through it. So if I had a loved one pass away, what should I do next?
Yeah. So whenever you have a death in the family, you need to bring those documents or facts to an attorney who knows what's going on with regards to probate. There are times, not to confuse anyone, that maybe a will doesn't have to be probated, but let an attorney tell you that, okay? Because I would say most wills should be probated most of the time. There are times in which we have simple families and there's some very easy facts where we can get around it, but I think most of the time you want to have that will probated. Remember, this is how you transfer legal title. If you have property, you probably like to have a deed with your name on it. And a will is a good way to make that happen. So
Right.
let's not beat around the bush. Sometimes you do these to be safe. Sometimes you do it just because you're over planning. Sometimes you do it because you have to. And let an attorney tell you that.
Yeah, absolutely. And there's certainly times when people thought that they set everything up to go directly, and thank goodness they did have a will because something didn't work out correctly, or long-term care insurance reimbursed them after the fact. Well, that's a check made payable to the estate. If there's anything that comes in payment-wise after someone passes away, you cannot put it into their bank account any longer, even if it's open. So an estate is the only way to cash checks. No. Sometimes those checks are small, so it makes the cost of probate not make sense, but it just depends on your particular situation. If you, let's say, were a single person with one bank account and you had your kids listed as beneficiaries on there, you probably don't have to probate a will in that situation because that will transition to the beneficiaries. But if you own land, or you own a car, or you have personal property that you want to go to particular people, or you have a disposition that is not equal shares to all the kids, or you have a blended family where you have another spouse involved, those are all times to make sure that you not only have a valid will in place, but that you have told your executor that they will need to probate that will, so that is not a surprise. What does the executor need? So if I were planning for my kids to have an easy time and I wanted to make sure they had everything, how could I best set up my child as the executor?
Well, I mean, I would name them in the document itself as independent executor. I would have a backup or two backups in the document naming who would be the next independent executor, which means they can serve without bond or court oversight. It's going to allow them to act freely and quickly with regards to comparing to like a dependent administration or not independent executor where everything has to be approved by the court, which is a slow, terrible process sometimes, just involving multiple heirs. So I want to name the independent executor. I want to make sure they have or know where the original will is so it can be found and located in a timely manner.
And have access.
It does, yeah. If you get it locked up at the bank, it's a process to get it. Your family, when you pass away, your family will go through grief. And the last thing they need to be doing is fighting with different institutions on how to get hold of your important documents. So have that laid out. I would, and this isn't really will related, but as the executor, I would love to know, hey, where are the bones buried? Where do mom and dad bank at? Where do they have life insurance at? Where do they have their investments? Where do they keep the important stuff at? Like a nice death list, a death guide, just a list of assets, because your kids, they hear you bank at Bank of America, but they don't pay attention.
You don't have to call it a death list either.
Yeah. Something more positive, but it's just a list of assets and really make their job easier. Some of my advice to clients when they come in is, hey, I'm the executor. What do I do to figure out what they own?
Absolutely.
I say, hey, watch the mail for the next 6 months.
Happens every day. If you have not prepared your children or talked to them, and people don't because either they want to retain privacy, that's fine. You don't need to tell them how much money is in the account. You just need to tell them the account exists so they know where to go, or they don't want to burden their kids or talk about death. You are going to pass away. That child listed as the executor is going to have to clean up everything that you have. So they will be dealing with personal property, with cars. They'll be dealing with selling a house, probably. They'll be dealing with trying to find your bank, trying to find all these different annuities or CDs that you put all over the place. So you can do them a real kindness by one. I love consolidating. That's not legal advice. That's just good practical advice if we're trying to make it easier for your kids or loved ones. Consolidating and having them a paper list that they could pick up. I keep a folder, so I keep an annual statement I get from life insurance or other accounts. I keep it in a folder. So if I died today, someone could walk in, look at that folder, and know where they needed to call. It's maybe not the most current statement, but we get them started.
A list of insurances is great information, from anything from your car coverage to your home coverage to your life insurance. You pass away, some of those places only send out quarterly or yearly statements.
Yeah.
Like, I know mom has life insurance, but I don't know where. I know they have house coverage. I'm not sure through who. Well, you pass away. These coverages need to be transferred, and your executor wants to do a good job, and they're thinking, hey, I could be responsible. I want to make sure insurance is transferred. I want to make sure we're covered until it's time to divide. And that's just an added stress.
Yeah, and forwarding mail is actually a little difficult upon a death as well. So, if nobody's in the home collecting mail, if there's a neighbor, that can be helpful. If you can get the mail forwarded, but the post office won't talk to you unless you're the executor. Sometimes you can do it online, but that can be tricky in and of itself, just getting the mail forwarded to you so that you can review those things. And of course, a lot of those places, if there's a forward, they'll send it back, right? If it's financial mail or from a bank, they will not forward it. They will send the mail back. So making sure that you've done the kids just a real favor by having those things in place so they know where to go.
Yep.
And have good expectations about what will be expected of them and what they'll need to do. We have on our website a list of the roles of the executor. That's a good thing to share with kids, as well as an after-death checklist, which is something, whether you probate or not, is a good checklist of, okay, I need to notify pensions that this person has passed or other income. I need to call and notify their supplemental insurance policy. There's going to be a to-do list of places that you'll need to notify. And like Chris mentioned, having Letters Testamentary that allows you to make those calls, get information on the mortgage, get information on the car, that can be made a lot easier that way.
Yep.
Yeah.
Awesome.
Yeah, so probate is not a bad process in Texas, especially out in East Texas. You can get through probate in, I would say, less than 30 days from start to finish. To have Letters Testamentary, so it's not something to necessarily be avoided, although there are situations where people try intentionally to avoid probate. But if your estate plan includes a will, and it does not include a trust or other beneficiary designations, your executor should be prepared to go talk to a lawyer upon your death and determine whether they need to probate that will or not.
Yep.
And that probate process requires hiring a lawyer, requires going to court, and requires getting appointed as the executor when you then get your Letters Testamentary to go handle the affairs of the estate.
Yep. And of course, your executor has to know what happens in your life. So if there's important events like a nursing home and Texas Medicaid, make sure you pass those events and notices on to the attorney. Those are information they need to know.
Yeah. Anything else you want to add? Okay. Well, as we've said before, very important to have your will and planning in place. We just didn't want to forget to mention, also very important to make sure and probate that will so that title transfers the way that you want it to. So anyway, good to see you. We'll see you next time.